This meeting is being recorded.
Can you all hear me now?
Yes.
Okay, sorry, my voice is struggling a little bit. I was asking Miss Lynetta, because I'm not familiar with her work. So I was just asking if you do you serve just San Bernardino County only, or do you serve other counties as well?
No, our firm serves the entire state of California. Different attorneys in the office, we've kind of broken it down by geographical region. Because honestly, if you aren't practicing consistently in a certain area, you get hometowned a little. And so we want to make sure that we are the hometown crowd in every jurisdiction. So my jurisdiction is the Inland Empire area. Anything Riverside County, San Bernardino County, and then all the way to the border.
Okay, thank you. Forgive my voice, but I can start off. My name's Natasha Falgren, and I'm the consortium manager for our Healthy Start Enhanced San Bernardino program. We're a program that offers free services to families that are pregnant or within 18 months of having their baby. And we offer them mental health services. We offer them group activities where they can come and get help with lactation or learn about childbirth and parenting. And then within our consortium is a cross-sector partnership with organizations and community members where we create plans to reduce infant mortality in the county. One of our work groups is a housing work group. We're working to look at housing solutions to help families. A lot of our families are looking for housing. A lot of our families are being evicted. A lot of our families are living in unsafe conditions, but what they have said is they don't know their rights. They don't know how to navigate those situations. They don't also know how to access housing, or they have trouble doing so. So we wanted to put this training together for them so they can know how to do those things. So I thank you all for being available and making yourselves available to present today.
Ashley, do you want to introduce yourself?
Hi, good morning. My name is Ashley Dial. I'm sorry, I'm trying to pull up. I'm using a different computer, so forgive me in my dinosaur ways. But my name is Ashley. I am the outreach coordinator for the Inland Equity Community Land Trust and also a member of the IE Tenants Union in San Bernardino, California. I am a tenant, renter, potential homeowner, and a frustrated renter that is here to shed the light of things that I don't even think my mother or my great grandmother knew. And unfortunately, that's what you know some of us. Um, my stepdad used to say, "We don't know what we don't know," and some people perish for a lack of knowledge. So when I was able to connect with the tenants union and the land trust, I learned so much about tenants' rights that I didn't know. That yeah, we're here now. Some people are remaining housed. We're educating each other and empowering each other. And that's what we're here for today, to ensure that the women, like when they're in their program, that they have the knowledge and the resources that they need. So when they do get their own place, they know how to navigate um, tenants issues, or if they do have issues, hopefully they don't, but that's what we do. And we're also in the wherever they are, we also try to get involved civically, but that's like another conversation to learn about how we can get like rent stabilized and all those other good things. But for now, we're just going to go over our tenants' rights for today. And it's a pleasure being here with all of you guys.
Thank you, Ashley. I am a former homeowner and now a current renter, and I don't know any of this information, so I'll be learning today along with others that might not know either. So this is
Oh,
all
wow.
information to me as well.
Oh, wow. Okay. This is exciting.
Okay.
And can we introduce Laura from Inland County Legal Services? And then we'll turn it over to Lynetta, I think, for the first part.
Sounds great. Hi, good morning, everybody. I'm Laura from Inland Counties Legal Services. I'm in the Systemic Impact Litigation team. And the ICLS in itself, we advocate and provide legal services to people that are low income with disabilities in the San Bernardino and Riverside County area. We target those services to the greatest social and economic need possible. So mainly the systemic impact litigation team focuses on like highly impactful cases, but we're a very large nonprofit firm and we have numerous different areas and practice groups which we assist people with issues in those areas. So that includes housing, consumer law. I had to write this down because there's so many. Disaster relief, elder law, expungement, family law, immigration, guardianship, health law, LGBTQIA+, public benefits, systemic impact litigation, which includes me, a small business clinic as well, tax and bankruptcy. And we also have a lawyer in the library program in several different libraries throughout the Inland Empire, where we have a lawyer come in, and if people come in from the community, they can sit with the lawyer and potentially get advice if it comes down to it. So they're there for that. So it's amazing. It's a great program. So each group is committed to their clients and to provide their legal advice if needed, consultations, direct representation in some cases where, let's say, we have a whole litigation going on. And we take a holistic approach. So if our client is having issues in other areas, for example, so let's say we have a housing case and they might need public benefits, like maybe they need Medi-Cal, right? Or SSA, whatever the situation is, we tend to work together as a group and like refer them to a different practice group because we have that resource. So it's great, and we provide it at no cost to the clients that do qualify, which are generally low income clients. And for seniors, there's no income eligibility. So for seniors, it's great. It's even better. And since this has to do with housing, I wanted to highlight our housing group. Our housing practice group's mission is multifaceted. The group's goal is to preserve housing for our clients, so that's what we're going in for. We typically don't represent landlords. The team's focus is to fight evictions, foreclosures, and unfair terminations from programs such as Section 8. So that includes unlawful detainers. The housing team also provides legal advice and education on several other tenant and landlord issues. So sometimes we'll have clinics that will advertise like know your rights as well. So stuff like this. And then depending on the case, we may offer legal education, counsel, advice, representation, go to hearings, same thing, negotiations, all of that. We also have a housing hotline that people can call, and the housing team provides legal advice over the phone. Sorry, is there too much background noise? Let me know. We're good? Okay, perfect. The applicants who qualify for services regarding various tenant or landlord-tenant issues may call the hotline, and we can determine if we can help them then and there. The housing team helps clients access the legal system through unlawful detainer clinics, held both virtually and also at several of our branch offices, just to make it accessible to people. And yeah, just like in the in those situations, we typically have an attorney that evaluates the participants' legal issues as well and has them do an intake so that we can determine if we can help them. So we have a lot of different resources to potentially help. Another really cool one is that the housing team provides unlawful detainer representation in many court locations throughout our tenant landlord assistance program, which is called TLAP. So an attorney and a paralegal are present to assist parties who have a scheduled unlawful detainer trial, which is basically like an eviction case for somebody. That's just what it's named. The attorney will review the legal issues and can assist with negotiations or potentially trial representation then and there. Because sometimes that's what it comes down to. You're showing up to the trial, and ICLS is there. We are located doing this program. We go to the Corona Courthouse. We go to Banning, Barstow, Fontana, Joshua Tree, Moreno Valley, Menifee, and Palm Springs. So that's the housing team. I wanted to highlight all of those resources. You can also go to our website and we have those resources there. I don't know if I should give out the phone number yet, or if you want me to just direct them to the website, but feel free if you're a senior, call the senior hotline. It's located at the very top of our website. And then the intake line, we always recommend you call early or you walk into our offices to get an intake appointment and determine if we can take on your case. So that's it. Thank you guys for hearing me out. And if you have any questions, just let me know.
Thank you. And if you need to share slides or anything, you should just be able to do that. I'm sorry I didn't mention that before. I wasn't sure if you were trying to share slides. Lynetta, would you like to talk a little bit about what you guys do? I just want to highlight that Lynetta is one of our champions that's fighting PAMA management and slaying the dragon. So she's one of our heroes.
Well, thank you. That's very sweet of you to say. Yes, so I am one of four attorneys from Elder and Spencer. We are a civil litigation firm that has dedicated our entire careers to landlord-tenant law. We only represent tenants and have only represented tenants as a firm for its entire existence. We practice all through the state and proudly suing PAMA all over the state. Eventually, maybe we'll sue them enough times that they will finally mend their ways. We were also very assistive to the Department of Justice when they were doing their initial investigation to start their case as well. So we provided them deposition transcripts and things that we had done along the way that were helpful for them to pursue their case. So that's just a little bit of history on us. We are trial lawyers, like I said, and we take on habitation cases primarily throughout the entirety of the state. And I've been asked here today to give a little tutorial, if you will, on tenants' rights, particularly for, say, the young families or young families starting in their tenancy journeys. And before I cue up the slideshow, I just have one thing that if you take away one thing from this whole presentation, it is writing, writing, writing. A lot of times when people first move in, the manager or the landlord will just say, oh, just call me. Oh, just call me. Or go tell the manager in the office. If the words come out of your mouth and are not written on paper, it is if they do not exist. So if you make a complaint about a habitation issue and it is not in writing, it is as if it didn't exist, which in landlord words means they can ignore it because you have no proof it ever happened. So writing, writing, writing. A lot of times we hear from our clients, especially those who maybe hit a little speed bump financially, that the landlord has worked with them in the past, or that the landlord or on-site manager has agreed to accept rent late, and then they are shocked to then receive a 3-day notice, and even more shocked when the landlord moves forward with an eviction. If the landlord, the actual person who owns the property, not the on-site manager, who might be a delightful person, but the actual owner of the piece of land is okay with accepting your rent late, you need to get that agreement from them in writing. An email, a text message, something that is in their words and in writing. Otherwise, again, that agreement doesn't exist. And so it's imperative, especially in the Inland Empire, and especially in Riverside County, where the commissioners who sit in the eviction courts are none too friendly at all to tenants. As Laura can probably tell you, the commissioners are horrific to tenants in Riverside County. You want to make sure any side agreements about rent, especially accepting rent payments late, are in writing, because the rules around evictions are very strict, and landlords try very hard to do them exactly right because they want you out. And especially in the days of rent control, where some tenants are paying below market, it actually behooves the landlord to get you out so that they can put somebody in at a higher rate. So you want to make sure that you're protecting your family by putting everything in writing. And writing can be emails, it can be text messages, it can be any piece of paper that you have that you put words to, but just keep copies of it. Take screenshots, keep your emails, and take photographs before you turn in that piece of paper so that you have a record for yourself. And that's especially important with respect to these rent agreements to accept rent, rent late. I get a lot of calls for people who say, uh, the so-and-so manager said it was okay to pay by the 5th. And then on the 3rd, they got a 3-day notice. And then the landlord won't accept, even a partial payment. It's like, well, that manager had absolutely no authority to have given you that agreement probably to begin with, especially in a PAMA property, by the way. And if in the Inland Empire, that's pro management, legacy management, high tower management, bridge management. There's also golden management and royal. If any of those are your management company and the manager on site says that they'll accept your rent payment late, they don't have the authority to do that. So if your rent is in fact late, they can move forward with that eviction because they don't have authority to do it, and they don't ever put it in writing anyway. So that's something you need to keep in mind, especially young families who are just getting into housing and don't know any better. So if you take anything away from today, writing, writing, writing. Let me queue up and see if I can actually manage to do technology today and share my screen. Here we go. I think hopefully this will share. Nope. I gotta actually run the darn thing first. Sorry, tech is not my friend. I have people that do this. If anyone will tell you, slideshow from the beginning. There we go. Zoom.
You're not alone.
Hopefully it works this time. Okay, yay, everybody's seeing things. That's excellent. Okay. And hopefully I can then manage to look at that. I can do things. Okay. All right. So this is the four of us, the gang of four. We've known each other for decades. We are all very close friends, and we work tirelessly uh, until the wee hours of the morn every day, actually, for tenants. Some of us are night owls, and we work a lot of hours. But what is habitability? It's all the things. If it makes you go ooh in your apartment, it's a habitability issue. Now, things that are not habitability issues, uh, paint that doesn't look very good, a baseboard that might be cracked, things that are more of a cosmetic nature, not habitation. But if it leaks, and it shouldn't, if you're not getting enough hot water, if you're not getting enough hot air or cold air, those are all habitation issues. And now, since January, an unworking refrigerator or stove is also a habitation issue as well. For leases that start or are renewed, that's a trick, or are renewed after January of this year, the landlord has to provide a working refrigerator and working stove. Fun fact, the Pama properties, they oftentimes rent them with stoves in them, and then tell the tenant that they don't actually provide stoves, which is a surprise to the tenant since the stove was there to begin with. Now the law requires that that stove work. The caveat to that is the wording of the code. So, say you started your tenancy after January of this year, you needed a working stove and a refrigerator. If your tenancy started sometime last year and it hasn't come up on its year renewal date, then they don't have to provide one yet. But at that renewal date, then they do. We're running into the situation where some landlords are saying, well, it hasn't renewed yet, so we don't have to do it yet, which is not optimal. And obviously, the legislature needs to fix that particular problem in the code because, people could exist for, 11 months and then no working stove. Eventually, that'll work itself out because eventually the code will be around for more than a year. But for right now, we're in that weird gray area spot. Um, Front door locks with deadbolts that work is a habitation issue and a fairly immediate one as well because it's safety first. Also, window locks, it actually has to be the locking mechanism technically under the code and not one of these little $2 jobs that you can get from Home Depot. Now, if you don't have a lock on your window, I highly encourage you to go get the $2 little guy because it works, but it's not code compliant and the landlord should actually provide actual windows that lock. Also for windows, every single bedroom has to have a window that fully opens. And for the living room kitchen space, if they are one kind of contiguous space, that also has to either have a door or a window that fully opens. We run into situations where sometimes there won't be a window that actually opens because they've decided that the way to make a locking window is just to simply screw it closed. And that violates fire code. So you should also report those issues to the landlord as well. When you first take your unit, a lot of times good landlords will just simply give you a move-in sheet and say, write all over it. Whatever still needs to be done, write all over it. There are other landlords, PAMA comes to mind, where they will have all of that move-in sheet in the stack of papers that's part of the lease. It is pre-filled out. Generally speaking, tenants do not get their keys until after they sign that lease packet of paperwork. So they have signed the move-in sheet without ever seeing the apartment. And then once they do see the apartment and realize it is nothing like what they've been told it is, then there's nothing, they verbally tell the manager as they're walking through, the manager says, we'll take care of it, and then it never happens. So I always encourage people, anytime they're moving into an apartment, to look for that move-in sheet. Sometimes very sneaky landlords will hide it in a pack of other paperwork and not do what they're supposed to do. Look for that piece of paper. If there is something that describes the condition of the apartment, you want to pull that piece of paper out and say, I'm happy to fill that out with you when we're in the apartment. But I'm not going to do it before I see the apartment. Because at the end of that piece of paper, for just about every form I've ever seen, it has a line that says that you are swearing to the condition under penalty of perjury. So you're basically signing that that document is true without ever having seen the apartment. So you want to make sure you're pulling out that piece of paper and saying, I am happy to fill this out. Let's go over to the apartment right now and we'll do that. And if they are refusing to let you do that, that should be a gigantic red flag for you that this is probably not the place for you to rent. Okay. Now, health effects of habitation conditions. Now, this is something that I figured new parents would be particularly concerned about. There's a lot of scary on the internet, especially about mold. Remember, there's an entire industry around mold that is determined to scare everyone about it so that people spend money to deal with it. The science says one thing, that you can basically get either an allergy reaction or an irritant reaction from having mold growing in your home. Just like you can get those kinds of reactions when you encounter it in the outdoors, like when you're playing in the grass or doing gardening or anything like that, because mold is everywhere. So when you're seeing it, Google's not your friend, but you should be writing out your maintenance request and turning it in. And oftentimes we see it in two forms. The first one is leaks. The second one is condensation and humidity. So that can be because the fan in the bathroom doesn't work, or the landlord's bolted the window shut, or it's just not ventilated because it's a really old property, and the landlord hasn't made it so that it can ventilate. So you want to make sure that you're complaining to the landlord about that issue early and often, because it is their obligation to deal with. Now, it's also it falls under a tenant obligation too to make sure that you're airing out spaces that maybe get a little bit misty. Like if there's four people in one bathroom and obviously multiple showers, you want to make sure that that door stays open, and that if the fan is operational, you're using it, or if the window is openable, you're using it as well. Because under the most leases, it does give the tenant some obligations there. Also, rodents and roaches and can also cause skin reactions that rodents can bite, obviously. Um, and the It's well documented, especially in pediatric cases, that cockroach feces can also contribute to childhood asthma. So, if your kid is experiencing these kinds of things and you are seeing cockroaches in your home, it's probably good to ask the doctor to do an allergy test for the exposure to the cockroaches, because that piece of paper confirming the allergy can be very helpful too in complaining to your landlord that pest control needs to be done. Oftentimes we see when pest control actually is done, the tenants feel like the pest control only made the roaches worse. And That's kind of a twofold problem. If your landlord is not doing what the industry is calling for it to do, which is to simultaneously treat all contiguous units, so that when the roaches run from one, they're only going to the poison in the next one. If the landlord doesn't do that, or if the chemical that's being used has an adjutant, it's meant to get the roaches from their hiding places out of their hiding place to run across the poison or consume the poison. So oftentimes, at least for the first few days, it does feel like they got worse. So it's kind of a twofold problem. But the big thing that we are seeing is the lack of follow-up by both pest control provider and landlord. Again, standard in the industry is that the landlord is supposed to follow up with the tenant to see if the treatment worked, and oftentimes they don't at all. They also have a tendency to not let tenants know when pest control is showing up. They just do and knock on doors, and whoever happens to open that day, that's who gets sprayed. Uh, so, and they're not told how to prepare or when to prepare, or if they do happen to take everything out of their cabinets and spend their evening doing all of that, and the pest control doesn't show up at all. So, these are common problems that we run into with our clients, and we tell them repeatedly to complain in writing, and then be your own follow-up. If the roaches are still there within a few days after the treatment and you're still seeing them just as plentiful, then complain again in writing. Let them know it didn't work. There's also, and we'll go over this a little later, a way too that if the landlord is not providing the pest control that is actually getting rid of the pests, you can do a repair and deduct situation, but you have to do it in a very specific way to comply with the law. Otherwise, you could be subject to eviction, and we never want that to happen. Okay? Also, and I know this is sad and gross, but cockroaches can crawl into the ears and noses of children. And especially with those who are neurodivergent, um, they can be eaten, which is not awesome to watch. Just be very boisterous about the cockroach situation in your apartment. It is a health and safety concern for you, for sure. There's also resources. You can complain to the health department or vector control. You just have to look to see which in your county is which. For San Bernardino, the health department is a county. For Riverside, it can be either city. If you're saying Hemet, the city of Hemet takes care of pest complaints. Or if you're in Riverside proper, it's the county that does vector control. So you just have to make sure you're complaining to the right entity. Because, like in San Bernardino, if you're complaining about roaches to code enforcement, they're not going to care because that's not their jurisdiction. But it is the county's, which is their health department. So you just have to make sure you're complaining to the right entity. But you can get your landlord cited for the pests. Here's my slide about complaining, and writing. Always writing. Otherwise, it's as if it didn't happen. And they're kind of counting on it not happening. Also, with respect to Pamela properties, the depositions that we have indicate that the maintenance gentlemen throw away the copies of the maintenance requests that tenants actually do submit on the little forms. They just simply throw them away as a matter of practice. And then it's as if they don't exist. So unless you're keeping a photograph of what you've turned in, it's gone. So make sure you're keeping copies for yourself and keep copies in a cloud situation. Phones break, phones get damaged by children, dropped in puddles, whatever. So you want to make sure you're backing up your data to a cloud. Also, if you're having consistent problems, you want to be photo documenting all of these issues. If something is leaking from your ceiling, take a photo. If a mushroom starts growing out of your ceiling, take a photo. Even if you think you just took a photo of that cockroach last week, take a photo again because it shows that the landlord isn't making those repairs. And even better, if you are sending your maintenance complaints by way of text message, send the photos. It's really hard for a landlord to say you don't have a roach issue if you include the photograph of said roach. It's also really hard for them to say your roof isn't leaking if you send them a video of it leaking. So, and it really helps to show notice if you do end up wanting to go the route of being fed up enough to sue your landlord, that you have the proof of sending them what was really going on in your apartment. And also complaining to code enforcement and public health, those entities want to see that you actually complained. And a lot of times they want to see first that you've complained in writing because, again, you can't prove to them you did so verbally. So they want to see that proof. They want to see the screenshots of the text messages or the emails or whatever. Some management companies are implementing an online only maintenance program. So you complain online. A lot of those are called like Appfolio and other kinds of things. And while in theory, if they are used honestly and actively, those are very good resources, we are also finding that they are very easy to manipulate. It is easy for someone to go in on the management side of things and simply click a maintenance request being done when nothing's ever been done to it. So we tell or delete them on the management side of things. So we are telling people that when you are submitting a maintenance request through one of these online portal systems, that you're taking your screenshot as proof. That way, if it gets deleted on the landlord end of things, you have your proof that you did it. Also, when you complain a second, third, and eighth time, you're writing, "This is my third complaint. This is my fifth complaint," and then taking again your screenshot, so that at least in your uh, proof, you've got it done. Another thing that we're hearing a lot is, "I did complain. They do know," but they might have done a lot of complaining 8 months ago, a year ago, and then not since. And a lot of times, on-site managers, they turn over a lot, especially with certain companies. They turn over often, and any knowledge that they did have of your situation has gone with them. For PAMA companies, the phone number for the manager is their own personal cell phone. So all those texts complaining, when that manager leaves, so do they. So there's no proof that stays with the company of the complaint. So you want to make sure that you're keeping your proof and you're being your own follow-up. You're being your own squeaky wheel, because the more proof, the better. Plus, if you're complaining and consistently and in writing, then it's harder actually for landlords to evict you, because then it looks like retaliation. If you're saying over and over and over and over again in writing, "I have this cockroach infestation, I have this leak, I have this, rodents, or my heater doesn't work," over and over and over again, if the landlord decides to terminate your tenancy or evict you, and you have this stack of paper that shows over and over and over again you were complaining about this issue, and then the timing looks a lot like retaliation, then you're going to have an edge in that eviction process. And that is especially true if you go a year and a day into your tenancy, because then you're also protected by the Tenant Protection Act, which means that the landlord also has to show good cause. So it's just an extra level, an extra bar. That's especially true if code enforcement comes out and cites, because then it's almost a slam dunk that it's retaliation if the landlord then seeks to evict within 180 days. So complaining in writing and getting code enforcement to cite actually protects you more than it puts you at risk, which I know seems counterintuitive to new tenants, but it's actually true. Okay, can you withhold your rent? The answer is no and never. Never, ever, never, ever. Do not do it. Not at all. The law does not allow tenants to withhold their rent in hopes of making bad landlords be good landlords. It's unfortunate, but it's true. You still have to pay your rent. You can do repair and deduct. And there, I get a lot of questions from people about repair and deduct and how they don't quite understand it. Generally, the populace seems to think, "Well, I just went ahead and I fixed the leaky sink, and so I should only have to pay my rent minus what I spent on fixing my leaky sink." And that's not actually how it works. So first you have to give a letter, an actual letter, to your landlord demanding specific repairs. And you do have to be specific. You can't just say, "Fix everything in my apartment." You have to say, "Leaky sink, cockroach infestation, heater that doesn't work," things like that. You have to be specific. I always tell them to include a bid from the handy person that you're going to pay to do that work. Because repair and deduct doesn't work if you are, in fact, a handy person who can do repairs. It doesn't allow you to basically bill for your time. You have to hire someone else and pay another person. So I say include the bid so the landlord knows exactly what you're going to do and how much you're intending to deduct. Then you have to give a full 30 days from when you give that to the landlord. I always say it's better to send it by certified mail because you have proof it got delivered. But it's a full 30 days. And after that, then you can hire that person to do that work and deduct the amount from your rent. It only lets you do it twice a year, so once every 6 months, and you can only do it up to the total amount of that month's rent. So you can't, if your rent is $1,000, you can't spend $2,000 on repairs and just deduct 2 months worth of rent. You have to do it in increments, but it does allow you to do that. Now, I always say if what you want the landlord to do is to get rid of a pest control issue, that you get an entire year contract from, say, Terminex or Orkin or whatever, an entire year's worth of treatment, the full scope, the clean out, the whole kit and caboodle. And that's the estimate and invoice you include for the landlord. So you get the upfront 1 year price, and then you include that because otherwise it's usually like $100 a month or something. And so then only 2 months worth, if you do it in the monthly way, can get deducted. And so that doesn't really get you to the finish line if your problem is pest control. Okay, so the Tenant Protection Act, I touched a smidgen on it. In January of 2020, the legislature enacted rent protections for tenants, and they are good, and they are a little less good. They don't have any real enforcement or teeth, unfortunately, yet. Uh, we're working on it. There's a whole cadre of attorneys who are working on it. But right now it's a little toothless. But here's the general sense. There is a cap on the amount that your rent can be increased, and it can only be increased once a year. The cap is 5% plus cost of living increase. There are great rent calculators on the internet that can give you what in your specific zip code that should be. Generally speaking, when the economy was booming, it was almost at that 10% cap. But now it's riding right around the 7%, 8%-ish area, depending on your zip in the Inland Empire. So just when you get your notice of rent increase, run it through the calculators online and see if it's legit. Sometimes, if it's a big company, generally speaking, it's usually the math is right. If it's a little mom and pop landlord, oftentimes they either have no idea what the Tenant Protection Act is, or they don't know how to calculate it correctly, and so they just do 10% when that's not right. So you have to be mindful of it. The Tenant Protection Act only applies to multi-unit housing that is older than 15 years. So there are some places, like in Orange County and San Diego, and a couple of buildings, not very often, in Riverside County, where the properties are less than 15 years old. And in that instance, Tenant Protection Act does not apply. They can raise your rent however much they want. If you are renting a single family home from human beings, not companies, but humans, Tenant Protection Act does not apply to that either. So they can raise the rent 100% if they want to. Now, if they try to do that right after you're complaining a whole lot, well, that seems retaliatory and you can have a claim against them for that. But generally speaking, multi-unit structures or single families owned by companies. Now, the it also provides protection against eviction if you are there for a year and a day. Doesn't kick in until a year and a day. So it gives you protection for that. The protections only mean that you have to have good cause to be evicted. Non-paying rent is good cause under the code. If they want to sell the property, it's good code. If they want to make substantial renovations, it's good cause. If they want to move their mom, sister, brother, whatever into your unit, also technically good cause. We get a lot of people who say, well, I'm on a month-to-month lease. It's not really a thing in California once you pass a year and a day because rent control and the Tenant Protection Act kicks in. and still it's just cause. Really, all that means is that you can give the landlord 1 month's notice, and still, before you terminate your tenancy. But really, it doesn't give the landlord the same ability. So it's really only one-sided. Oftentimes, landlords like to use the whole month-to-month situation in an effort of charging more rent instead of offering a year renewal. Sometimes they send out letters that say option one is month to month and option two is the full year. I always say just do the full year. But if it's cheaper, but that's just me. Unless someone's actually planning on leaving in 30 days, the year is probably your better financial bet anyways. And that's us, and that's our website. And from that website, you will find every phone number for every one of our offices. Like you said, we file lawsuits for tenants. We are extremely aggressive and very, very successful at doing that. We have quite a number of very, very happy clients, and nothing makes me happier than when somebody says, "Thank you. I am so glad I am no longer going to have to be a renter." So that makes me very excited. So usually when we have a bunch of people, I open it up for questions, but right now I think this is more of a recorded event. So I will sign off here. So thank you so much for your time.
That was great information. And I always hear people when you have issues, they're like, well, just withhold your rent. So thank you
Do
for
not do
letting us know we can't do that.
that. My two takeaways: pay your rent and put everything in writing. That's it. If you remember nothing else, that's it.
Well, thank you so much. And Ashley, are you raring to go?
Yes, I am. Let me so we're going to present. I'm going in the thing. We're going to present.
Did you have a question, Tasha?
Hello, good morning.
Hi, good morning.
Okay, go ahead.
Did someone have a question? Or was that just the background?
I think Tasha was just having background.
Okay,
If
all
you
right.
have
Well,
a question, Tasha, you can ask it.
I think it was just background.
Okay.
okay. Well, I'm here. I'm going to be giving a presentation. It's a renter's rights presentation. If you would like to screenshot, or I'll put the, what is it? The presentation in the chat if you want to reference it. I'm using this MacBook and I have no clue how to use it, so please forgive me. Okay, now let me see. How do I share?
At the bottom, you should see a button in the Zoom meeting.
Okay, share window.
Got
Can
it.
you see it?
Well, there you go. Yes.
Yes. Okay. All righty. So today we are going to and it's this presentation has like 40 something slides. I know Lynetta had touched on a lot of the key points, so we'll probably just breeze through some of these things. And Jeff, when we get to the rent increases, I would like you to, if you can, elaborate on all that good stuff.
I just want you to be mindful of the time too, because
Oh yes, that's why I'm gonna breeze through
okay.
it. So
Okay, welcome to the Renters' Rights Workshop. We're just going to skip through this. The goal of this presentation is to empower you guys through knowledge. You guys will gain essential knowledge about your rights as renters, including legal protections and responsibilities. Understanding these rights empowers tenants to advocate for themselves in various situations. So as a tenant, especially as a mother going into tenancy, please feel empowered. Please know that, you had a baby and you're a mother for a reason, and that is to be a protector, and not just of your baby, but just future things that can happen in your life. And so please feel empowered. I know I'm one of the renters from one of these slumlord companies, and the aggressive tactics that they use, it's so discouraging and so disheartening. So we're here to give you the fire that you need, the knowledge that you need, and the safe space to know that as a renter you have rights. And when you pay your money, you're entitled to certain things. And so by the end of this workshop, participants will understand the legal frameworks surrounding rental agreements and the significance of maintaining documentation and effective communication with landlords to protect their rights. So, securing your security deposit and prorated leases. So make sure, like, when you move in, you look at your lease, you read it. The security deposit, like if you move in the middle of the month, the next month should be prorated. So if you move in, the rent is 1,700, you move in on the 15th, and next month they're asking for 1,700 again. You might want to pay attention to that, because it can happen. And common pitfalls in lease agreements can lead to misunderstandings and disputes. Tenants often face issues with unclear clauses regarding maintenance responsibilities, rent increases, and penalties for breaking the lease early. It's vital for tenants to it's vital for tenants to thoroughly read and negotiate their leases, ensuring all verbal agreements are documented in writing and protect their rights. And that's very important, because right now, like, a company took over the apartment complex that I rent from. And so still to this day, it's over a year, we have no leases, no leases, no leases. And so it's important. And even when we ask, they're just a little different. So it's very important to, if you don't have a lease, if you do have a previous one, to go on what they gave you. And if it gets too hectic, just consult an attorney. And that's why Lynetta was here um, uh, explaining all the great things that she does, because sometimes the loopholes they want you to climb through, some people don't have the time to navigate that. And so if it gets too crazy, it might be good to exercise your rights and start looking for other people to collaborate with, because it's going to get worse, unfortunately. And so, law surrounding rental increases. Okay, notice requirements for rent increases. If you're a tenant, and this is just really quick, if you want to write this down, they have the tenantprotections.org. They have a rent calculator. So if you're not sure what the rent increase, if that is happening, that conversation is like, hey, you got a letter saying your rent is going to be increased. You can go to tenantprotections.org, and they have a rent calculator where you can put your zip code in, and your time frame, the date, and they will show you legally how much they are allowed to increase your rent if you're not sure. Because I had used that last year before my rent increase, and it was legal, unfortunately. And Jeff, I don't know if you want to briefly go over this slide.
So there are different notices required for rent increases depending on your circumstances. So, for instance, if you're receiving some sort of uh, help with housing, like Section 8, or on some sort of voucher program, or in a LIHTC, or a low income housing tax credit unit, then your required to receive 60-day notices for rent increases. If, on the other hand, you're just in a rental, paying out of pocket and everything else, then you can receive notices up to 30 days. Whoa. Ashley, put the slide back on. I don't want to see me. That's
Oh, I'm sorry.
okay. The and so, I mean, that's generally what happens if you're protected by Costa-Hawkins, which is the bill that covers multifamily units over 5 units or more. Then in the IE, that's pretty much the only rent control is that Costa-Hawkins bill. So you have to be in an apartment that's older than 15 years and has more than 5 units. Then they can only raise your rent the maximum of 10%, but it's a formula that Lynetta was bringing up. There's all kinds of calculators online that you can use, but it's based on the cost of living increase and plus 5%. And so sometimes that, is, it could be as low as 5% a year, which is still, we got to fight that. But anyway, that's the limit on those types of units. Other units, they can just raise the rent however much. There are, some cities, but not in the IE, that have rent control, and it might be different in those cities. Like Los Angeles has a lot more renter protections than, say, the city of San Bernardino. And we are, we're looking for ways to get the city of San Bernardino to consider some sort of rent stabilization, rent control, renter protections for just cause, to expand the unit types, because those are the things that cities can do. But right now, this is the situation that people are in.
So, like, let's say today is the 30th, rent is due tomorrow. So if your landlord comes today and say, hey, we're increasing the rent, tomorrow we want $400 more, that is illegal, and let them know that.
Right. And so they do need to give you proper notice.
Yes, because there are people that, I mean, the practices are real, real aggressive. And so just remember, notice, city, and also if you're not assured, just be empowered and just make sure that you find the proper information you need, but just don't give in, because sometimes you want to give in because you just want to stay housed. And so you have protections also against retaliatory increases. So landlords cannot impose rent increases as retaliation for tenants exercising their legal rights, nor can they increase rent based on discriminatory reasons. This protection ensures that tenants can assert their rights without fear of financial repercussions from their landlords. What I've been doing recently is my landlord has been really getting hostile and aggressive. So every time they tell me certain things, I just respond to her in a text message that it is illegal to retaliate against tenants in the state of California, according to Civil Code 1942-5, and that just shuts them up immediately. Because, yeah, you'll go back and forth, and you'll be stressed out. And as mothers and families, the only thing you should be worried about is taking care of your kids, making sure they're developing and all that. You shouldn't have to worry about um, arguing back and forth with management companies, and they should know better. So in San Bernardino, the annual increase limits in San Bernardino is the same as the state. So it's 10%. We don't have, or 5%, whatever the CPI is. And so that's where we are trying to, as a city, come up with ways that we can have the city draft up ordinances that can protect, because a lot of people are being priced out of their communities, their homes, unfortunately, due to these rent increases, until the city can draft up something that protects tenants and keep them in their areas. So the crucial role of record keeping in tenants' rights. Lynetta was very thorough in explaining writing, pictures, writing. It's very It's very important. Like even for myself right now, like I get so tired of dealing with the crap, but still I have like a book that I keep my camera ready to go. Sometimes I miss things, but it is very important to write. Even if you just, keep a little notebook with you. You walked outside, like I walk outside, I see roaches walking around that didn't pay rent. So I'll take a picture, I'll write the date. Hey, roaches are walking around or they're swimming in the laundry room. Unfortunately, that's been a main concern that I've been having. But make sure if you have your phone handy, snap it really quick, send it over and let them know like, hey, if we could take care of these issues. But you're writing, take yourself back to school. If you don't like school, love it today. So I'm just gonna skip over this. Effective documentation. Make sure your documents are effective. Like if you have rent increase notices, if you have code enforcement documents, public health, environmental health, make sure you keep it in a folder, and keep your times, your dates, your pictures. If you can, try to print them out if you can, because sometimes this stuff is costly. And make sure you're clear in your communication as well. Try to save, not try, make sure you save your maintenance request forms, your papers. I have this thick, I don't think you can see it. I have this thick folder, file of all types of papers for the last year. It looks like I'm a lawyer or something, but it's going to be very important. Your communication. And like I said, if you don't know something, go to Google. If your landlord is telling you something you're not sure, just Google it. I Google it. Hey, is it illegal for the landlord to do this? And once you find that out, write it down, send it over to your landlord management company. And if you can send a letter, do that as well. The benefits of communicating with landlords. Importance of written communication. Written communication Written communications are essential as they provide a tangible record of interactions. This is especially important for ensuring that agreements are honored and disputes are minimized. Effective written communication helps to clarify issues, establish accountability, and serves as proof in legal context if necessary. I'm sorry, someone was knocking at my door. And so make sure that your communication, it's written. If you can try to keep a diary, keep a diary, keep a diary, keep a diary. Legal notification requirements. Legal requirements mandate that landlords be notified in writing for specific issues such as maintenance requests, lease violations, or termination notices. This fulfills obligations under the law and protects tenants when formalizing their requests or complaints. And so make sure, okay, let's go. Okay, yeah, you're making sure so you can reduce misunderstanding, writing. Okay, yeah. So pest control laws and timelines. I'm sorry, really quick, Jeff. Can you go over this really quick?
I think Lynetta spoke a little bit about this, but you have a right to live free of vermin and live. I can't quite read what you have on the slide, so
I'm pissed
um,
at work and I'm banging on my door. I require notices.
okay.
Tell your
I'm gonna mute Ashley here for a second.
I'm pissed. I know, I'm on your thing. Sorry.
Are you?
All right, I'm sorry. And here we go. This is another thing. When a landlord comes to your house, they need to provide a 24-hour notice, because I have a maintenance person banging on my door right now and I have no notice. I'm sorry, they're just banging on my door and I'm in my living room. So if you're a tenant and your landlord likes to come and knock on your door on all days and hours of the night, that is illegal. They have to serve you proper notification. That's just a side note.
No.
I'm sorry about that. So if you ever run into an issue where your landlord is knocking on your door, banging on your door, looking for you, let them know. According to California Civil Code 1954, you have to provide me a 24-hour notice unless it's an emergency and this place is burning down. They're not your friends. They can't just pop up at your house. Oh, alrighty. I'm sorry. Okay. And pest control laws and timeline. Did we go over this, Jeff?
I talked a little bit about, Lynetta spoke a little bit about, like, not living with vermin. I can't read the slide because it's too small on my screen, other than I can see pest control there. So, um, right. So when you sign documents to move into a place, you get a list of things like, it'll say about ticks, it'll say about other things when you sign your lease on the apartment. So they're giving you notification of whether or not that particular property has been treated for specific types of bugs and whatnot. Um, the
And I got it. Look, I got it, Jeff. And it is illegal. It is illegal for roaches and bed bugs and all these critters to live in your house and they're not paying rent. If you have that, just make sure you text them, do a maintenance request. And like Lynetta, I think we're going to go past this because Lynetta was kind of thorough that if you need pest control, it's a good
mhm.
idea. You can do a repair and deduct. And so if you have roaches, I remember growing up, I used to play with roaches and we used to make roach traps. I thought it was normal. It's not normal. And I don't want to, share my lived experience, but like I just kind of thought growing up, and I'm 39, living with roaches was normal, and it's not normal. It's unhealthy. It's unhealthy, and it's not normal. So landlords are required to provide tenants with information on how to identify bed bugs and reporting procedures. I know when you in California, they make you sign like these bed bug addendums and all that. So make sure. What I do is I put I don't know until I move in. And so, because sometimes you'll move in, the place looks really nice, and then the bed bugs will be in your bed at night, tired as well. And it's unfortunate. And current trends, emphasis on proactive pest management strategies and increased tenant awareness of their rights regarding pest control. So these are pest control timelines. Once again, I'll include this renters' rights in an email so you guys can receive this as well. And so maintain cleanliness. That is a responsibility as a tenant. Make sure that, you keep up with your apartment. You throw away your trash, wash our dishes, all that good stuff within your unit. So it can maintain cleanliness. So, roaches and all that good stuff won't come. But it's unfortunate that if your neighbors are like filthy as well, I mean, filthy, that, the complex or the company does what they need to do to ensure that your apartment stays clean, because you can be the cleanest person all you want, but like a couple of my neighbors around me, when they moved out, the manager didn't clean the units quickly enough, so all those roaches from them empty units will travel into my apartment, and that's their job to ensure that the apartments are cleaned out, proper waste disposed, that the waste is disposed of. This is the next slide, because sometimes, like, even if you're the cleanest person in the world, you might have a neighbor, or you might have empty units. Because I had walked into one of the units next door to me, and it was filthy. It was full of trash, food, and it sat there for like 3 weeks. And so when I'm complaining to the, landlord, they're like, "Oh, this is your problem," until I went next door and snapped pictures of their empty, filthy unit. And I had told them, "No, this is your problem. We need pest control." So make sure you promptly report problems, send pictures, um, Google if your landlord, because some landlords, they are going to tell you what they don't do. They will lie, they will lie, they will lie, they will lie. And so you, as your own diary, make sure you ensure your own um, record keeping and report problems promptly. And try to Google if you can to make sure, because my manager, I mean daily, someone was just banging on my door right now, and I've told them multiple times, I need a 24-hour notice before you do any work. And they're just banging on my door right now, and I had no clue they were coming. And so I'm going to promptly report that when I get off the phone. But make sure that you Google. If someone tells you we don't provide pest control, go get on Google really quick. Or if they say, "Hey, you have to pay us this or do that," try to Google it before, because a lot of our um, tenant friends, they're not empowered, and they're fearful, and they start paying. I had a lady tell me she paid $800 in eviction fees. She wasn't even supposed to pay because she wasn't aware, and she was scared. She didn't want to lose her home. So, and it is illegal. It is illegal for infested units. We'll move past that. Um, Understanding your rights as an immigrant tenant. Immigrant tenants have specific rights too that must be upheld, including the rights of fair housing, protection against discrimination, and the ability to seek legal recourse if those rights are violated. It's crucial for immigrant tenants to know their legal protections and the resources available to them. So if you know of any tenants and they're illegals, let them know they have rights. They can't, um, they're not supposed to be taken advantage of, because I had ran into that with my daughter's school. There's a lot of illegal immigrant families that said that they're, you know, being threatened with evictions daily. And I had let them know that they can reach out to me. But if you know any immigrants, let them know, illegal immigrants, that they have rights. If they're paying money, they have rights because they're not living for free. And so, understanding tenant rights. Tenant rights include protections against unlawful eviction, the right to a habitable living environment, and the right to privacy. Understanding these rights is crucial for tenants to safeguard their interests. Importance of legal aid. Legal aid organizations provide vital assistance to tenants facing eviction, discrimination, or housing violations. They offer free or low cost services, ensuring that all tenants have access to legal help regardless of their financial situation. And gathering documentation. When facing legal issues, tenants should gather all relevant documents, including leases, correspondence with landlords, and evidence of any violations. This documentation is crucial for legal presentation and effective advocacy. And so just make sure you have all of your documents. If you city to city, it could be different, but like Jeff mentioned earlier, Pasadena, LA, they have all these wonderful tenant protections and legal resources that if you are facing a UD or unlawful detainer or retaliation or whatever, they have some amazing resources to help assist you guys navigate those situations. And acting out common tenant situations. We won't do this because this was for a workshop where we acted out some scenarios. Ensuring safety and stability in emergencies. We know that life happens, and sometimes renters have no choice but to stay in rough living conditions. Low income renters are especially vulnerable to being taken advantage of with unfair fees and unsafe housing. Protect yourself by learning about California's habitability laws, which require landlords to provide safe and livable housing. Always document your living conditions by taking photos, keeping notes, and saving copies of communication with your landlord. If you experience unsafe conditions or unfair treatment, seek legal counsel or tenant support before taking action. Never stop paying rent. Never stop paying rent. without a plan, as this can lead to eviction. Always get legal advice first. And policy and advocacy. Pasadena, they have some rental stabilization ordinance and some great protections. San Bernardino is in the process of working on rent control. And as a mother, human, tenant, whoever, getting involved in tenant advocacy is very important. Participants are encouraged to engage in local tenant advocacy groups, attend council meetings, and educate themselves on housing rights to make their voices heard in policy decisions affecting their communities. So if you can, try to get involved in advocating your city council meetings, board of advisor meetings, and write letters, learn who your people are civically. So if you do live in a space, San Diego, Orange County, or wherever, and they don't have rent stabilization ordinances or rent control, learn how to get involved so those protections can be implemented. And I hope this was a great workshop. I hope you guys learn some great things about your rights. Yes, and if you know of any illegal immigrants that are facing, issues or discrimination, let them know that they are protected in the state of California and to not worry. It sounds good, but make them feel that fire. And my last thing is, if you can, unite with your tenants, your people, come together, network, and share like camaraderie, because it's strength in numbers. You're alone is okay, but you're more powerful together. And I just want to say, a neighbor of mine, I don't want to get into the raggediness of what was going on with him, but his apartment was Molotov cocktailed, and he was not supposed to get another unit. He was not supposed to be put into another unit. But because of the noise that we're making out here in San Bernardino, the manager see me outside, and she immediately gave him another unit in fear of, us doing what we do, networking, coming together, and letting them know that, we need to stay housed. And he was lucky to benefit to get him another place, because the situation, his girlfriend cocktailed his unit, unfortunately. And so the manager, she doesn't know her rights or tenant rights. And so that benefited him. But it's because of our network, our unity, us coming together to empower each other. If I don't know something, Jeff knows something, or if Jeff doesn't know something, Sungmi might know something, or Natasha might know something. So the more we come together, get to know each other, the more we have a chance to, share and fight this housing beast, because we're only in the beginning. People that are going to be moving into, apartments and getting Section 8 or, low income, those housing costs are increasing. They went up from 30% to 36%. So let's say you move into, a unit because the federal government is going through what they're going through, and you get Section 8 or low income housing, they are increasing rent as well. And so you just want to make sure that you understand certain things before you just pack up and move out. Because I have a lot of people, sometimes they're like, I don't want to do that. I just want to move. And because they're scared. And there are some people, they're like, you know what, I'm going to fight this good fight. And when we fight, what do, Jeff? We win. So, so thank you guys for your time. And I hope you mothers, God bless you and your babies. Remember, take 5-minute breaks if you need to, if you can.
Are there any questions? And I just want to open the floor up for that.
Maybe is there any current advocacy work that we can collaborate and get involved in that you guys are currently working on?
So we're in the city of San Bernardino working to I don't know, this is a C3 space, so I can't really talk a lot about it, but we are friendly with a candidate for city council. We do want to try and push for some sort of renter protections in the city of San Bernardino. If we can get our ideal, which is on our website, ietu.org, is the Pasadena or the city of Anaheim's rent control laws. LA has a lot of good things going on as well, but there's kind of like three stools to rent control that you want. Or three stools to renter protections. You want obviously rent control that's reasonable as far as covering rent and the rise in rent, but you also want to have just cause eviction protections so that they can't just evict you for remodeling and things like that, which they do a lot. And then you also need some sort of rent board that enforces the renter laws, because without enforcement, the landlords kind of just ignore the law, and then you're required to go out and hire an attorney and everything else, and who's got money for that? And so certain types of renter protections can be enforced. In Pasadena, they have a rent board that also allows them to collect data on what landlords are charging for rent, so that they know how much rent increases are going to be, and you can definitely enforce Costa-Hopkins if it's in place. Cities can also include more unit types that are covered, and so by like the Tenant Protection Act and other kinds of renter protections. So it doesn't have to just be 5 units and above, and in buildings that are older than 15 years. Those are decisions that cities can make. So if we can't get all of those things, one of the ideas we had was to try and do a ballot measure in the city of San Bernardino to try and get those kinds of renter protections in place. Join us every other Saturday. It's on our calendar, which is also on our website, ietu.org. And we meet at Ecclesia Church every other Saturday.
Well, thank you, Jeff. And thank you, everyone who came to give this.
Are there any other questions?
Can you guys hear me?
Yeah.
I was saying thank you to everyone that came to present today. Really appreciate it.
Oh, thank you.
Yeah. Sunmi, do you want to talk about designs?
Thank you for joining us.
Hi, everyone. Hi, Natasha. Thank you guys so much for all those really wonderful presentations. A few of us students made a pretty rudimentary design that we have about different legal service and hospitality rights that Lynetta and Ashley and everyone and Laura all talked about. So they're very, we worked on them with global communities, and I think Natasha would be able to distribute some of those later. But yeah, it was so nice to learn about this stuff, and thank you, Jeff, for all your